bom dia, pessoal, é para os que estão remoto também. Essa é a nossa primeira reunião presencial do ano, né? A gente teve uma primeira reunião online do Comitê de Concorrência, então só queria passar alguns recados bem rápidos, porque a ideia aqui é a gente aproveitar o tempo do professor para discutir aqui esse tema que não podia ter sido melhor escolhida a data, né? Acho que foi uma feliz coincidência. Então, só alguns recados do Comitê de Concorrência. A gente, semana passada, fechou a data do seminário internacional por uma questão da disponibilidade do local. Esse ano vai ser em São Paulo, no Renaissance, que já é conhecido aí de alguns por edições passadas. Por uma questão de disponibilidade do local, a gente mudou a data, então ela estava para 24 a 26 de outubro, agora ela ficou de 1º a 3 de outubro, a data do nosso seminário internacional. O comunicado oficial com o Save the Date vai em breve para todos, mas também já queria aproveitar aqui, o que significa que a gente vai adiantar o edital um mês, tá? Então, quem já estiver planejando apresentar painéis, agora é a hora de começar a pensar. Esse é o primeiro recado. O segundo recado, a gente ainda está recebendo voluntários que queiram revisar os artigos do livro que a gente pretende lançar no Seminário Internacional, um livro sobre critérios de notificação, está sendo coordenado pelo Eric Jasper e pela Nabatia. Então, quem mais quiser se voluntariar, a gente promete não inundar os voluntários com muitos artigos. E aí, o terceiro recado que eu queria dar é a gente tem curso já o grupo de trabalho de ativos, em face aí até do último julgamento, do julgamento recente do CAD, a gente remodelou um pouco o que é o resultado desse grupo. A gente pretende dar encaminhamento, uma discussão, tanto no nível do tribunal quanto na superintendência. Acho que alguns de vocês viram que o Cordeiro, na última sessão, falou sobre um grupo de trabalho para revisar a Resolução 33. O IBRAC já se colocou à disposição do CAD para participar, e é o que a gente sugeriu para eles, fazer nos moldes um pouco do que foi feito no grupo de trabalho sobre leniência, que é fazer algumas discussões antes da consulta pública, porque uma vez que o texto vai para a consulta pública, a gente tem visto que as mudanças quase não acontecem. Então, a gente está querendo ter a discussão antes, mesmo trazendo professores, acadêmicos, pessoas de fora. A ideia é contribuir com o tribunal. Estamos esperando aí uma indicação deles de quando a gente pode começar esses trabalhos. E a gente vai soltar muito em breve um novo grupo de trabalho, uma chamada para quem quiser participar. Esse grupo de trabalho é uma iniciativa do Pedro Zanota e do Mauro Grimberg, que estão querendo discutir dores de processos administrativos. Então, a ideia é discutir aspectos processuais que hoje são adotados pelo CAD, aí não é com relação à lei, não é mudança legislativa, mas mudança no procedimento mesmo, que dê maior clareza, maior transparência, que evite uma série de nulidades que lá para frente o judiciário possa contestar. Então, é um grupo que vai ser coordenado pelo Pedro e pelo Mauro. A gente vai fazer o chamamento em breve para quem quiser participar. Com isso, eu encerro os meus recados. Let's switch to English. First, I want to say thank you very much for Professor Joseph Tringali for being here. I think the idea is to have a live debate. So I know you have something to tell us. I'm pretty sure that the audience here has a lot of questions. And thank you once again. I will give the floor to Caio to introduce our guests today.
Thank you, Renata. Thank you, everyone. And welcome. Very nice to have this first in-presence meeting with this discussion, and to welcome Joseph Tringali to our community here. I mean, the antitrust bar in Brazil is very active, so it's very good to have you with us. Joe Tringali is an adjunct professor at NYU, New York University, also at the Hong Kong University, and used to be until recently, as I understand, in Miami University as well. And has had an experience as a practitioner at Simpson Thacher for over 30 years, I understand, yes. Joe, and so with a wealth of experience in merger control. So it's really nice to have you here and to hear you about the merger guidelines and actually the new Trump administration. I think everybody's kind of like trying to understand what's going on in the US at this point. So we're very eager to hear you. Thank you very much for being with us.
Okay, and I am among those wondering what's going on in the United States. The one nice thing about being here is that I don't have to be listening to the American news constantly. You know what the newest issue is of the day. But in any event, I want to talk first about the merger guidelines before talking about the Trump administration and what I think one can expect from that. In terms of the guidelines, let me just give a very brief overview. So in the United States, unlike in most other jurisdictions, the federal agencies cannot stop a transaction. They have to go into court, and the judicial branch of the United States has to prohibit the transaction. I'm not going to start immediately by making comments as to how Trump would like to do that, but in terms of executive versus legislative and judicial branch. But in any event, so as a result of that, it's important in terms of what the case law says, because the agencies are only as powerful as the courts, as the cases they have to bring to the courts. And there are two cases that, believe it or not, were both decided by the United States Supreme Court in the early 1960s that still remain good law in the United States, and in many ways shape the merger guidelines to some extent, at least, to a large extent. And that's because in the United States, anti-merger cases never get up to the United States Supreme Court. They typically, most of them will end at the district court level, which is our lowest court, because if the trial court decides to enjoin the transaction, I've had this happen in cases that I litigated. The last one I had was in 2015. The two largest food distributors in the United States were trying to merge. The district court enjoined it, pending an FTC administrative law judge proceeding, which would have gone on for another year or two. We had already been in the merger review process for close to 2 years. And at that point, after the district court decision, it was decided to just drop the transaction. There was a termination fee paid to my client, who was the acquired party. So as a result, sometimes the cases will go up to the appellate court, which is one level above, but you only do that if there's a discrete legal issue, okay? So, for example, in the case that I'm talking about, the Cisco US Foods case, there was a 150-page opinion, or more even, with many, many detailed factual findings, no obvious error of law. There's nothing you could bring up to would have been the district court, the circuit court for the Court of Appeals for the District of Columbia. So we just ended it. Sometimes, and this really is more the government than private parties, typically private parties will end it after they lose at the district court level. The government typically, not typically, but when cases are appealed to go to the appellate court level, it's typically the government. So the government, for example, one of the leading cases that remains in the United States today is what we call the baby food case, where in the United States, Gerber was the leading manufacturer with like a 65% share. Two smaller manufacturers, Heinz and Beechnut, wanted to combine. They were both around 15%. So they would have been at 30%. Their argument was this would make them a more effective competitor. But the government lost at the district court level. They then appealed to the District of Columbia Circuit Court, the appellate court, and the appellate court agreed with the government that a 3-to-2 merger was presumptively illegal in the United States, just based on market concentration, that it would lead to coordinated effects by having fewer players. Economic theory would suggest that you could have it make it easier for coordination. There's also unilateral effects that you go into, but that just shows the importance of case law. And the one case that I think is, there's two cases. One is brown shoe, which is how you define a market. Although quite frankly, the way the merger guidelines define markets today is much more sophisticated than brown shoe. Brown shoe is much more anecdotal evidence. What do people think? How is it presented in terms of industry reports and the like? And today we do the hypothetical, the SNP test, statistically significant, non-transitory increase in price, hypothetical monopolist test, the sort of econometric analysis that wasn't available in the early 1960s when the Brown shoe case was decided. The other case, though, that was decided that really you see in the merger guidelines forever, the 2010 guidelines, now the 2023 guidelines, is a case called the Philadelphia National Bank case, which is a case that recognized a structural presumption that if, and in that case it was, if the resulting combination was going to result in an increase in a market share of 30% or more, the government would have a rebuttable presumption that the transaction would be illegal under our statute, which is Section 7 of the Clayton Act, which prohibits transactions that would substantially lessen competition or tend to create a monopoly. While that is the, that the 30%, quite frankly, is not, it all depends on what the market share cannot really be divorced from market concentration. So 30% alone is not the problem. It's 30%, let's say in the Beech Nut Heinz case, the baby food case, it was 30% when the other competitor had 65%. So you had two people with 95%. So it's not market share versus, it's not market share alone. It's market share plus market concentration. That is the first step in the merger guidelines in terms of a government investigation, which is obviously first defining the product market and geographic market, which has been very consistently applied. I don't think there's going to be any change in the Trump administration with regard to that. But then it's going to be, once you define the market, what's the market share and what's the market concentration? And we have these, you know, from the Herfindahl, and I have this all laid out in the presentation. But you do the Herfindahl analysis where you compute market share and pre-merger and post-merger, and there are guidelines. There are guidelines in the 2010 merger guidelines. There are guidelines in the 2023 as to if you're within this range in terms of whether it's a unconcentrated, moderately concentrated, highly concentrated market, and what the change would be, whether the government would challenge or not. And actually, if we can just, sorry, this one? Yeah. No, yeah. Let me just make sure. Yeah. Go ahead. Okay. So the 2010 guidelines, for example, looked at, had these ranges, and then you see how to calculate the HHI, which you may have had experience with. The one thing that you really have to keep in mind, both with 2010 and then 2023, 2023 made the merger, the market share, market concentrations, even stricter under the Biden administration. The one thing I always tell my students from having practiced is these numbers are dramatically lower than in practice, okay? I have never seen a transaction that at these lower numbers, okay, that gets challenged. The transactions that get challenged are, we're talking about a post-merger market concentration of 5,000, a change of 1,000. I mean, the numbers aren't going to be that high, but the numbers typically are that high. If you have a unilateral effects case, for example, so you know, some of the leading unilateral effects case, well, Cisco US Foods, the food distributor case I did, was a unilateral effects case. So the judge found that as far as national broadline food distribution, which is food distributors who could distribute food to restaurants, hospitals, hotels, whatever, throughout the United States, there are only two viable players, okay? Those are the time. That doesn't mean that you know it's only when you have a monopoly and only when you have 100% share. But the cases that get challenged by the government are not 30% shares unless you have the situation like a Beech Nut case. Yes,
Professor.
Yes.
how do you see, what are the reasons for that approach where just the higher concentration cases are actually prosecuted? Is that prosecutor discretion?
Yes, yeah. So the government, the way it works is we file, if it meets the statutory burden in terms of approval, we file, and then the government investigates. And the government has complete discretion whether to challenge or not challenge a transaction. And there's no requirements for them to challenge a transaction, even if it resulted in 100% share. They always have complete discretion as to whether to challenge a transaction. So it's always discretion. But and I think one of the reasons why the numbers are much lower than in practice is when the government goes into court to challenge a transaction, they always cite the merger guidelines, saying that this violates the merger guidelines. If they had higher numbers, it may hurt their cases. So they always have much lower numbers, and they go into court and say this exceeds the merger guidelines by so much. Okay, so it favors them in court. The one thing I've always found as a practitioner odd about the merger guidelines in terms of courts is that courts accept the merger guidelines to some extent as if they are case law and established, which to me has always seemed very odd. Obviously, to the extent you're citing the merger guidelines, and it's because the merger guidelines are relying on Philadelphia National Bank, that's perfectly proper. But where it's just, this is the way the government is deciding to do X, Y, or Z, that's no different than me having a case and writing a law review article as to why my position is correct, and then that's becoming law, which to me makes no sense. But in any event, that is the reality. But so we spend a lot of time talking about the structural presumption and the fact. So in terms, let me just explain why this idea of the presumption. In the United States, because we have this process and this requirement that the government agencies cannot stop a transaction, they have to go into court and get a court to do that. It is then the rules of civil procedure in the United States, civil litigation, which is that the government goes into court. It has the moving party in a case in the United States, civil litigation, they have the burden of proof, okay? So they go first, and they have to establish enough facts, enough evidence that the case then goes to the defendants to rebut. And so you will often see at the end of a plaintiff's case, the defendant moving to dismiss the case, saying that the plaintiff hasn't made out the elements of its claim. To give a non-antitrust example, let's say there was a traffic accident, or let's say there's a negligence case, okay, that says someone went into McDonald's restaurant, glorified name. But anyway, went into McDonald's, there was water on the floor, they slipped and fell and they injured themselves. The plaintiff would have the burden of proving that there was this hazardous condition, negligent condition, that the person fell, the person had injury. Let's say they did not prove, they had to prove all of those elements. Let's say they didn't prove that there was any injury. The defendant, McDonald's, would then argue that the case should be dismissed because they didn't meet their burden of proof. They didn't meet their burden in terms of their case. With the Philadelphia National Bank structural presumption, the government gets a presumption that they have shown enough evidence just based on market share and market concentration that the burden shifts to the defendant, that there has been a substantial lessening of competition just from the market share and market concentration, okay? While that is true, and that is the law, and in every case I've had with the government will cite that in terms of why they satisfied their burden of proof. I have had no case, and know of no case, where the government rests solely on market share, market concentration. So for example, in the Cisco US Foods case, the food distributor case, They definitely showed and cited Philadelphia National Bank and relied on the fact that there was this structural presumption, they had met their burden of proof. But they also put in testimony from customers, how these customers thought that their only alternatives were Cisco and US Foods, that they relied on competition between the two. If the competition was eliminated, their prices would go up or quality of service would go up, would decrease. They would have testimony from the executives of the companies that are merging in terms of the nature of competition. So while we spend a lot of time talking about the structural presumption, the fact is that when they go to court and when they do their investigation, they at no time stop with the market share and market concentration. It's a much more robust analysis. The 2010 guidelines were very sort of structured in terms of saying this is the step-by-step process we do. Okay, we first define the product and geographic market. We then measure market share, market concentration. We then look to other anti-competitive effects, such as particularly unilateral effects, where they're each other's closest competitor, so that the elimination just of the two will result in increased, a lessening of competition, or coordinated effects, which is the 3-to-2 type merger, where it's going to be easier for the parties to engage in collusive behavior. And then also spells out the defenses that the parties have, the efficiency defense, ease of entry, and this appelling company defense. The efficiency defense is one thing that I think potentially will be used more often. I'm sure it's going to be advocated more often in the Trump administration because it's the efficiency defense. So I'll give you an example. In Cisco US Foods, we were relying very much on an efficiency defense. There was going to be something like, I think I'm going to get the numbers wrong, but something like $5 billion worth of efficiencies from the transaction. And typically, when it was at the Federal Trade Commission, there was 5 commissioners. At the time, this was under the Obama administration, so there were 3 Democrats and 2 Republicans. Typically, mergers that the FTC voted to challenge were 5-0 decisions, or at most, or 4-1 decisions, because there was one commissioner, his name was Joshua Wright, who basically believed that there was almost no merger that was unlawful because they were efficient. In Cisco US Foods, though, we got a 3-2. There was a 3-2 vote with a commissioner by the name of Maureen Oldhausen, who's a Republican, voting against the challenge. That was the only time that there was a 3-2 vote during the Obama administration. And the reason was because of the efficiency defense and the view that if there was an efficiency defense, which is recognized in our merger guidelines, this was a case for it. Okay, so that I think the prevailing view is that the efficiency defense is in our merger guidelines, but is in fact not ever applied. It's anytime it has been tested in court, it's been rejected by the courts. It has 2 requirements. One is that the efficiencies have to be merger specific, meaning that they could only occur but for the merger. So for example, if you're talking about an elimination of a CEO, because you don't need 2 CEOs, that's merger specific. But if you're referring to cost savings from adopting some new procurement policy, and there was no reason why the acquired party couldn't adopt the procurement policy on their own, that's not merger specific. And then secondly, and often, by the way, the efficiency defense is turned down just based on the fact that the efficiencies that have been shown are not been shown to be merger specific. So we only get to the second step. And the second step is that they then have to be passed on to the customer. And that's one that often, what typically happens is the CEO of the acquired company says, we're going to pass them on to our customers. And what the government then typically does is has evidence that shows in the past when they've achieved efficiencies, what they did was they got higher profits, profit margins. They didn't pass them on to the consumer. Yes.
When you say that the efficiencies have to be merger specific, you mean, because of the example of the two CEOs, you mean they're specific for any merger, not this merger in particular, for
That
example?
they could only be achieved by merging. Okay, so in other words, the only way you could eliminate having a CEO at the acquired company is if there's now a CEO
Okay.
for the two companies together. Okay, whereas if there's something that the acquired company could have done on its own, it's not necessary for the merger to occur. So merger specific just means it can only be done if there's a merger.
It doesn't have to be that specific.
No. It only can be done because of.
Because of a merger, right?
Yeah.
Thank you.
So I do think though, because the reason why I mentioned about the 3-2 vote in the Cisco US Foods case with the two Republicans saying that they would have not done the transaction based on efficiency, is that the efficiency defense is definitely something that is going to be favored by the Republican administration. So I think you're going to so potentially at least it's definitely going to be argued more in the Republican administration. But it's also something that in fact, I could see the Republican administration, Trump administration, agreeing with. It is not something that I see the courts changing on that. So I think it's going to be something that if the efficiency defense is going to be recognized and permit transactions to occur, it's going to be at the agency level before going to court. Because if you go to court, the fact that the government now has a better view of efficiencies in terms of saying it's pro-competitive, that doesn't change the legal standard that the efficiency defense under case law has to be merger specific, and you have to show that the costs are being passed on to the consumer. And so it's going to, if there's any change, it's going to be in the clearance process as opposed to in the courts. Case law is not going to change. It's going to be a change at the at the agency level. I'm also going to, I'll talk in a few minutes about the broader Trump effect, because I think the efficiency defense is going to be used in a much broader way as part of it. I perceive it's going to be an America First type argument. But I'll get to that later, which is not an efficiency defense, by the way, but it is a way to use an existing defense that exists in the merger guidelines to appeal to something that is become a hallmark of the Trump administration. The 2023 guideline, well, first let me talk about the 2023 guideline. So in 2010, the Obama administration updated the merger guidelines, and they were just horizontal merger guidelines. They were not, we did not have vertical merger guidelines. And that's because in the United States, unlike here in Brazil and elsewhere, vertical issues are playing much less significance. The only time we really pay attention in the United States is when that is the essence of the transaction. So for example, AT&T Time Warner, it was a vertical merger. Most recently, Microsoft acquired Activision. Microsoft has one of these game console. I don't play video games, but one of these game consoles, and Activision does Call of Duty, which I guess is very popular. Again, I've never played Call of Duty. Those are the types of cases that we do in terms of vertical mergers. We don't do, and our filings don't require us to notify all vertical relationships. So I'll give you an example relating to Brazil and elsewhere, actually. I represented Silver Lake, which is a private equity firm, and acquired Dell computers, okay? Silver Lake, and many other of my private equity clients, had interest in other portfolio companies. And some of those companies had a vertical relationship with Dell where they supplied products that Dell was using, okay? Components to laptops, for example. In the in Brazil, in the EU, China, elsewhere, we had to provide information, as I'm sure you're aware, with regard to all the product overlap, all the vertical issues in terms of products that Dell was buying from Silver Lake portfolio companies for the authorities here in Brazil and CADE and other in the EU and elsewhere to determine whether there was the possibility that Dell's competitors could be potentially foreclosed or have their costs raised as a result of Silver Lake now using its portfolio companies to disadvantage competitors of Dell. That's what happened here. That's what happened in the EU, China, elsewhere. In China, quite frankly, we didn't get that resolved until literally like days before the transaction drop dead date was. In the United States, we got early termination. Okay, so not even a question as to there were any vertical relationships. Okay, so that explains, I think, why we didn't even have vertical guidelines until 2020, and that was after the AT&T Time Warner case, where we first had vertical guidelines. They were then withdrawn, and in 2023, when the new guidelines were issued, they are now merger guidelines that address both horizontal and vertical. But while they now incorporate vertical as well, we're not at the level, we're never going to be, I don't think, at the level of Brazil, EU, China, elsewhere, where we're talking about vertical, all these vertical relationships. It's only going to be the AT&T Time Warner type case, the FTC Activision, the Microsoft Activision type case, where the essence of the transaction is a vertical merger. The most significant difference, though, in the 2023 guidelines is that the analysis is essentially the same, but what they've done for the first time is put in 11 sort of principles of competition law in terms of merger guidance. And so the first is that the merger should not significantly increase highly concentrated markets, increase concentration in highly concentrated markets. They're just now giving a guide, an express statement to what already was incorporated in the merger guidelines. So it really isn't representing a change from 2010. It's just now highlighting it as a principle of competition law, merger competition law in the United States. So it's really nothing more than saying market share, market concentration, Philadelphia National Bank presumption. And again, while it talks about even a small increase in a concentrated market, and it has for the first time this, if you have a firm with a 30% or greater market share and a post-merger increase of greater than 100, again, no case I'm aware of has challenged a transaction with that low a number range. Okay, so the 30% share being challenged is the example I gave you where the other competitor had a 65% share. But if you had a 30% share in the merger, and they were, let's say, get my math wrong, but let's say then there was a 25% share, another 25% share, and a 20% share, I would be amazed if that would get challenged. Okay, so what the guidelines say and what in fact is going to happen is two very different things. If you have at least 4 competitors with roughly equal shares, 30, 25, 25, 20, that is not going to be a challenge. A transaction is going to be challenged, yes.
Are you aware of any specific examples of merger that had 31 and like 31% and wasn't challenged? Is there anything that comes to mind in the last few years?
I will tell you that I can only tell you the reverse, which is that I know the cases that have been challenged, and none of them have been anywhere near the numbers that you're suggesting. They don't report when transactions are not challenged. We don't have reports. Like the EU will issue a report about a case that it's not being challenged and why. We don't do that in the United States. You just get clearance. No explanation is provided. And you don't know the shares or anything like that. All that information is kept private. So, but I can tell you what the cases are that have been challenged, and none of them have been anything in those low rates. The second is merger should not eliminate substantial competition between firms. That's just unilateral effects. Again, it's something that was already existing in the 2010 guidelines. If you're the closest competitors This happened with Cisco US Food, it's a classic case. Office Depot Staples is another case in the United States. Whole Foods, Wild Oats, another. These are all cases where the argument of the government is in court that these are each other's substantial, closest competitors, eliminate competition between them. Regardless of who else is in the marketplace, prices will go up, or quality innovation will go down because they constrain each other to a greater extent than anyone else. And this is where econometric analysis has really been key for the government. The government's been able to show, for example, in some of these cases that if there are markets, let's say there are local markets around the United States, and there are local markets where these two competitors are competing against each other, and then there are other local markets where they don't compete against each other. They'll compare the prices and the profit margins, and they will show that there is a difference. So that even though, yes, they do compete broadly in a market, let's say for office supplies, in the case of Office Depot Staples, the argument in that case was that superstores, which are these very large outlets, competed to a larger extent or to a more significant extent. And the government was able to show through econometric analysis that in local markets where Office Depot and Staples did not face each other, that they had higher profit margins than in local markets where they did compete. Show that there was a intensity of competition that restrained their prices that was not the same as the other competitors. So that is, again, not something that unilateral effects has been something that has already existed. But again, in these 11 specific principles, it's now spelled out as a principle. Another one, which is coordinated effects. Number 3, merger should not increase the risk of coordination. The leading case in this is the baby food case that I mentioned, which is the 3-2. And this is one where obviously there's been collusive behavior in the past is always a factor, but this is one that really relies on market share, market concentration. Merger should not eliminate a potential entrant in a concentrated market. The issue here always, by the way, is whether the person really is a potential entrant or not. The acquired company is always going to say they're not, and the government will always look at their documents and find in their documents where they were in fact considering entering, and they have to explain that, yes, at one point they were considering entering, but then they decided they're not going to enter. Number 5 is really the effect of the merger guidelines, which is denying or raising rivals' costs, access to competitively sensitive information. The government in the United States has been unsuccessful in twice now. The AT&T Time Warner, well, 3 times actually. AT&T Time Warner case, the Microsoft Activision case, and the United Health Change case, which is a case that had a vertical issue with regard to sharing of competitively sensitive information. And the reason why the government has been unsuccessful is, first of all, the courts have always found that it is improbable that the acquiring company is going to act in the way that the government says it would act. So, for example, AT&T Time Warner, that it is not economically reasonable for AT&T to no longer supply the Time Warner product to competitors of AT&T in terms of distribution, because the money that they would be losing is not money that they're going to be able to recoup. And the other thing in the AT&T Time Warner case was that they committed that they were going to license, and they committed to what's called baseball style arbitration, which is that they would allow an independent, each side to put in their best offer and have the independent mediator determine the price. So there was no ability, even if they had an incentive, they had no ability to use the vertical relationship to hurt competitors. so the government in the United States has been unsuccessful 3 times now that they've gone to court, and it all started with AT&T Time Warner. We never had a merger challenge. And when I talk about the Trump effect shortly, one of the things I think you can look at too is what happened in the first Trump administration. And the first Trump administration, as I'm learning, was very mild in terms of what we're seeing today. So if in 2016, in the first Trump administration, they were challenging AT&T Time Warner because of his animus towards CNN, which was owned by Time Warner. This administration, I think, any animus, whether clearly having nothing to do with antitrust, but any animus will be acted upon. The rest, I don't think we really need to go into because they're just. I want to get to the Trump, what I'm calling the Trump effect, and the other ones are not as important. So the Trump administration, this person, the chair of the FTC, for example, Ferguson, has said that they do not intend to change the 2023 guidelines. And that's consistent with 2016, the first Trump administration. They did not change the guidelines. And his explanation was that the business community needs to have continuity and not think that the merger guidelines are going to, and not have new sets of merger guidelines every time there's a new administration. I don't think that should give anybody any comfort or belief that that means things aren't going to change. But there's no reason, quite frankly, to change the merger guidelines because they are just guidelines. Okay, there's nothing to your question about prosecutorial discretion. The agencies always have the ability to challenge or not to challenge. It doesn't matter what the guidelines say. So the guidelines are obviously low enough that the Trump administration can challenge any transaction they want to, but they don't need to make them higher, in terms of being more pro-business. Their actions will achieve that same result. So I do think that the fact that there's no intention to change should really say nothing for the reasons I just explained. So what are some of the obvious differences that are going to exist? First of all, in the Biden administration, for the first time, not even in the Obama administration, but the Biden administration, labor market issues were seen as an issue to be investigated by the government with regard to a merger. So that if, let's say there were going to be no price effect in terms of price to consumers, but let's say the two competitors were significant or each other's most significant competition for labor in terms of wages or in terms of other benefits of employment, that could be the grounds that under the Biden administration to challenge a merger. That was spelled out in the 2023 merger guidelines and was a subject of in the second the request for additional information. It was something that was looked at or asked about. I do not see that continuing in the Trump administration. First of all, even in the Biden administration, no transaction was challenged over labor. But in any event, I don't even see I definitely don't see the Trump administration. And in fact, it was something very new and novel in the Biden administration. So it's not radical that the Trump administration is going to reverse course on that. But the other two things that the Biden administration was looking at times in the merger investigation was DEI, whether the firms were competing on diversity, equity, and inclusion, or climate in terms of environmental policy. As you may or may not be aware, in the United States, Trump has declared a war on DEI. He is eliminating it throughout the federal government. He is threatening private businesses with not being able to do business with the government if they have DEI. So I am very comfortable that the Trump administration is not going to be focused on any elimination of competition with regard to DEI. And climate concerns, the way this was an antitrust, a competition issue was companies could compete in the past, or they can compete today for that matter, but on climate issues. So for example, a company can say that they are more energy efficient, or they are more committed to the environment as a way of competing with their competitor. And that for customers who are more climate conscious, those customers would be attracted to that company. Okay. And by, let's say, one company is acquiring another company, the company that was the acquirer was not committed to climate concerns, was acquiring a company that was, they would be eliminating that competition, that element of competition. Given the Trump administration's policies with regard to climate, where they denied climate change, I don't see that. I'm very comfortable saying that is not going to be a focus of the Trump administration. The one that I think is probably going to be the most significant is, as I'm sure you're aware, with the tariffs, which I think you guys so far have been luckily spared from. He hasn't discovered Latin America yet because he's lost in the Gulf of America, but
still is affecting us.
But the America First policy, tariffs, I see a potential of this affecting merger policy, merger clearance, in that I can envision American acquirers, lawyers for American acquirers who are advocating their transaction to, if they're acquiring a foreign company, to argue that the American company is somehow being disadvantaged in foreign markets. And by allowing this transaction, they will allow the American company to better compete in foreign markets, and therefore, and sort of make it a quasi-efficiency, even though it's not, it doesn't fit under the efficiency rubric, efficiency case law, but that it will appeal to the argument that we want to make American companies stronger, we want to make them better able to compete, and therefore ignore the competition issue that exists in the United States. I do see that happening. I also see the reverse happening, which is a foreign company acquiring an American company. I do see that at least if it is, I think if there's zero issue, I don't know, I look at the names of the companies. You may remember in China, there was this famous case, a very noteworthy case several years ago, where there was going to be an acquisition with regard to beverages. I think it's like an orange juice manufacturer, maybe soda or something like that. It was an American company that was making the acquisition. There was zero competition issue in China, but strictly based on China not wanting an American parent block the transaction. I don't, I'll get to a minute on CFIUS, but I don't think just on Section 7 of merger clearance that the Trump administration will far, although I think it's possible. But where there is a transaction, where there is at least some, even though it wouldn't be something that they typically would have challenged, if it is a foreign company acquiring a US company, I do see the Trump administration being more aggressive in terms of challenging the foreign position of a US company that otherwise would not have been challenged, but where there is at least a colorable claim. They're at least horizontal competitors, and maybe they fall at the low end of the merger guidelines. Okay. I don't think we're going to have the situation where there's zero, and the reason why I think we're not going to have the situation where there's zero competition issue, is that Trump can rely on and will rely on CFIUS, Committee on Foreign Investment in the United States, particularly with regard to actions from China, maybe or maybe not Russia anymore. Typically CFIUS has been it's been China, Russia, and Middle Eastern companies. The reason why I see him using CFIUS rather than the antitrust laws of Section 7 is, as I explained to you, unlike other jurisdictions in the United States, if the government wants to block a transaction for competition reasons, they need to go into court, get a court to rule in their favor. Under CFIUS, Committee on Investment in the United States, if the president determines on his own that a transaction involving a foreign acquirer implicates the national security of the United States, and national security has been expanded exponentially over the years. Okay, so it used to, start out with military equipment or something like that. It now is, has turned to safety of food supply, and things like infrastructure, so ports, terminals, things like that. It's now food supply. It's virtually, I think they could really make it almost anything in terms of the way you can define national security. Give one example which we thought of. My firm actually represented Alibaba when they tried to acquire MoneyGram. And this wasn't Trump. I don't think it was Trump. I think it was under Biden. I'm actually forgetting what it may have been Obama. But anyway, they blocked the transaction under CFIUS, not because Alibaba had any competing platform to MoneyGram, but MoneyGram was used a lot by U.S. military personnel overseas. And obviously, when you make a payment under MoneyGram, you have to provide personal information. And the claim from the government under CFIUS was that this would allow the Chinese to have personal information of U.S. military and could potentially use that information to recruit spies or whatever. But in any event, I see. But anyway, CFIUS allows the president to act unilaterally, okay? There is no judicial recourse. The only judicial recourse you have under CFIUS is to claim that CFIUS hasn't given you some due process rights to provide your information or whatever. There's no ability to go into court to challenge the CFIUS determination. So this is, perfect for Trump in terms of not having to worry about, not that he seems to worry about, but not to worry about judicial oversight because he can just have, and CFIUS is his cabinet. It's led by the Secretary of the Treasury, and then it's Homeland Security, Commerce, Justice Department. I'm going to forget everybody who's involved, but anyway, it's his cabinet, which I'm sure you've seen are all loyalists. So it's not exactly like it's functioning as something outside of whatever he wants. So I see CFIUS as being used more aggressively to achieve the result that is going to be more difficult to achieve going into court to block a transaction. Because going into court to block a transaction, they have to satisfy the test under Section 7 to show that it's a substantial lessening of competition or intending to create a monopoly. CFIUS, it could be America first. Okay, that's not an argument in court. So that's why I see that potential use of CFIUS. Go ahead.
Quite on the point, but I was wondering about cartel enforcement. Since that fighting international cartels could be used as a tool in a trade war or something like that. Do you see that happening?
I think that to the extent the cartel does not include U.S. companies.
Yes, sure.
Yeah. Yes.
Especially like the FCPA, the Foreign Trade Anti-Corruption Act.
Yeah, which you may have heard he's probably not going to enforce anymore.
Yeah.
So, or at least wants guidance on how it, he clearly would target, if there was a cartel operating without US companies, he clearly would have his Justice Department go after them, because very similar to, his whole argument with regard to the Foreign Corrupt Practices Act is that it is hindering US companies from doing business. There are a lot of things that hinder them from doing business, but the hinders them from doing business. Clearly, he could, that same argument would apply to cartels. Cartel would be seen as an unfair competition, just as he argues tariffs are unfair, right? So I think cartels clearly, again, if the US companies are not involved, which is the big if.
Professor, I have a similar but not directly related question, and it's rather sensitive, I guess, from our Brazilian perspective, but in terms of agency independence and function independence of the members of the government, obviously there were partisan choices to lead the agencies, both the DOJ and the FTC, but does that really imply from the perspective of the US that those individuals, they will respond to Trump's positions directly, or will they beat their own drums or align with more Republican widely accepted values or Trump directions? Because this might have an impact in not just things going to the CFIUs, but also the use of merger enforcement or cartel enforcement, for that matter, to reach other political objectives. How do you see that?
So
is that a problem?
Yeah, so the first however many days, it seems like it's been years. And my friends are always reminding us that we have a very long way to go. The person who is the current chair of the FTC was actually there already. So he's not a Trump appointee and not a Trump loyalist, but he was appointed to be chaired by Trump. So, and Trump will have to wait for an opening to put his own person there. But it is an executive position, and he's taking a very extraordinary position with regard to the executive branch, which is, I'm sure you've heard about all the firings. He's taking the view that he can hire and fire whoever he wants in the executive branch because he is the executive. And that there's no judicial oversight, there's no legislative oversight. So what he might do in terms of the FTC, obviously he has to deal with the 3-2, but in terms of majority party, but he will definitely, let's put it this way, people know that they are in their positions only so long as
Their loyalty.
Exactly. The woman that he has appointed to be head of the antitrust division, he is someone who is, as far as anybody knows, is definitely not is a real practicing attorney but she ultimately has to answer to Pam Bondi, who's the attorney general.
And she said that U.S. attorneys work for Trump, right?
Yeah, and Pam Bondi was one of his lawyers for January 6th and election denier and all that. So, and she's made very clear, her most recent thing is that if you attack a Tesla dealership, you can go to jail for 20 years. But if you storm the Capitol, you could get pardoned. So it's, so there is, there was a big issue in that, not a big issue, but there was an issue in the AT&T Time Warner case as to AT&T Time Warner, when they were defending, wanted to take discovery in terms of Trump's involvement in that decision. And Judge Leon ultimately decided that he wasn't going to allow it because his view basically was, at the end of the day, they have to prove their case. And whether Trump made them do it or didn't make them do it. And the real issue was that it raises lots of issues of executive privilege in terms of what they can get in terms of deliberation and communications and blah, 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 blah. But, you don't have to be a genius to realize that that decision was predicated on Trump's view, given that the day the transaction was announced, in September, I think it was, Trump immediately said that that was an unlawful transaction, attacking CNN. So the fact that then his administration challenged that transaction, whereas under the Obama administration, which obviously is much more liberal and much more pro-enforcement, there was a very similar transaction, Comcast, NBC, Universal, which they allowed with a consent decree. So, it's not like you needed to be a genius. And also, the person who headed his antitrust transition team when he won in 2016 was Josh Wright. And it was thought that Josh Wright would become the antitrust division head, but Josh Wright said that that transaction, AT to Time Warner, was perfectly legitimate, pro-competitive as a vertical merger, and he did not become antitrust head. Go ahead, sorry.
I just wonder, how do you foresee the CFIUS argument or approach being used, especially with digital platforms and also with big techs in general, because it seems like this may be an important argument and approach to use. It's not clear how Trump is going to treat them, because Biden and
Yeah, that actually is a very interesting issue, because Trump in his first administration was very anti-big tech. And for example, the Google case, I think even I'm not sure about when the Meta case of Facebook, but the Google case was started under Trump. But and he was very against these big platforms because he found them to be very powerful, and more importantly, he found them to be powerful.
Yeah.
As I'm sure you've seen, they are all doing everything they can to curry favor with them in terms of making big donations, doing things, changing their policies. So, for example, Facebook now doesn't check anymore, so you can or Threads as well.
The inauguration day was very.
Yeah, so they can now. So that they're no longer what he considered to be censorship of pro-Trump views. Can now, and I'm sure you also saw at the inauguration, as far as I know, the first time sitting like right behind were Zuckerberg, Bezos, and Musk. So I'm not sure who else, but so I do think, and obviously these people know why they're there. What they're doing, and I would be very surprised if they're not going to be rewarded in some way. So I think that while so long as they continue to curry favor with him, I think they're going to be rewarded. We're seeing with Musk, we're now getting involved. The U.S. is now getting involved with South Africa policy as if it's the major issue. United States, when the United States paid no attention, even under the first Trump administration, and it's not a coincidence that with regard to Musk in South Africa. So I do think that, but it'll be interesting because the Google case is pending. It's in the relief at the remedy phase. There's an active monopolization case against Facebook, Meta. Amazon's facing cases, and when they were making acquisitions under the Biden administration, they would always get challenged because they thought they were large enough and they didn't want to continue to add to their platform. So even though Amazon, for example, didn't have a particular product line, the argument was we're not going to let them get yet another product line. And and there's a current case that's seeking to require Meta to divest Instagram and WhatsApp, even though it was approved years ago, I think under the Obama administration. But that's why you see Zuckerberg there, and that's why you. I would have said even 6 months ago, I would have said that it's not going to change anything, but. I think the experience of the first Trump administration is not what we're seeing in the experience of the second Trump administration. The second Trump administration is really a Trump administration on steroids. So nothing would surprise me at this point because I'm getting surprised every morning when I read the newspaper. So nothing, nothing is out of question yet. Sorry, go ahead.
It's a bit disruptive, so you can ignore it. It's kind of philosophical. I mean, the Zuckerberg Tesla thing, it made me think about the ultimate goals of antitrust in the United States, in the sense that for the past 60 years it has been focused on economics, consumer welfare, price translated into consumers without other concerns. But originally, it was about making sure that economic power would not translate into political power, like in the beginnings.
Mhm.
When you see what is happening right now, this could be a concern. So definitely not in the Trump administration, but if the proximity between big tech and government and Elon Musk produces too much damage, do you see in the future, like 10 years in a post-Trump administration, that discussion coming about? I mean, we need to use antitrust for other purposes as well, including making sure that these super big corporations could not translate that power into.
I definitely think that there will be a correction. I don't know that it is conceivable that they could do it at the warp speed that's going on right now in terms of the dismantling. But I definitely think there will be a correction. I do think, though, that the correction is going to be much more gradual. I think there'll be an immediate return to sort of what antitrust policy was in terms of protecting consumer and the like, and also this concern about having companies being too big or too powerful will definitely be a concern. But I don't see even a Democratic administration coming in and using executive orders like we're seeing today, and reversing, trying to make it and making reversals. I think it's going to be a more gradual process, but I definitely don't think it's going to continue the way it is. But again, it's hard to predict what's going to happen and when it's going to happen. I'm someone who told friends in 2016 that there's no way that Trump would win the Republican primary. No way he would win the presidency. And in 2020, 2024 said no way he would win the primary or the presidency. So I'm not even going to guess what will happen in 4 years. I would have expected, obviously, I'm sure you sort of understand my political leanings, but I would have expected at this point Trump's approval rating to be abysmal. He's actually has a higher approval rating today. His approval rating is still below. I mean, his disapproval is higher than approval, but his approval rating today is higher than it was at any point in his first presidency, which to me is somewhat mind-boggling given everything he's been doing. But the one thing that I think is going to affect him and bring it down is the economy, and particularly the stock market. Because I mean, I don't know what the situation is in Brazil, but unfortunately, the United States, I think one thing that we've seen in the election is that personal self-interest seems to play a more important role than these other issues. Like world order or anything. So people's pocketbooks, if they're not seeing what they thought was going to be some great improvement in their personal life, is going to be the most significant factor, as opposed to the people who may be less concerned with that, but more concerned with the damage that's going on to the world in general. But you're starting to see this disapproval, but it's really, I think, related to the stock market and the economy and the price of eggs in the United States or whatever, as opposed to all these other things that you would read about and think people must be outraged, because unfortunately it doesn't seem to be resonating.
And when you think about the global impact of this, and just going back to your point on American First policy, do you see that could create a race to the bottom, in the sense that then Europe's going to actually foster mergers of European companies that will compete more, have more concentration in Europe. We had this discussion in Alstom Siemens, for instance, that Europeans were really upset of not approving that because they thought it would make their companies more competitive. And then have China doing that or having Brazil doing that. And then we're going to a race where we have market concentration national levels in a global competition.
Can I add something on
Yeah.
that? Because we're seeing at the UK level a similar approach that this Trump administration to be more pro-business. So they replace the head of the CMA, trying to be more pro-business and less burdensome. Today, there was an article in the news saying that they're willing to change the jurisdictional thresholds that the CMA is using. We see this as the beginning of a race.
I definitely think so, but I definitely think China will, because China's process has already, has not been following, the law. So I think for China, it's going to be an easy thing to do. I think the EU, I have more respect for the EU, but that doesn't mean that if the EU, I don't think the EU is just going to sit back. But I think they're going to be at least. I think China will match US tit for tat. I think the EU will be more measured. I think the EU is not going to sit back. And they're going to favor European companies, but they're also going. I don't see the EU approving a merger with regard to two European companies that create very high shares in the EU, simply to make that company more aggressive, more effective competitor in the United States. On the other hand, I do think that the EU will be, more receptive at a lower level that they wouldn't have been before. But I don't think they're going to be at the, I could see the United States, if it's a America first type thing, going to ridiculously high levels. I don't see that happening in the EU.
I have another question here, if anybody wants. And also we have like more than 20 people watching. So if you have any questions, please just throw in the chat or you can also participate live. So my understanding is that now the HSR form, the new HSR form is rolled out, right? It's already underway, and it's closer to the Form CO, like in the sense that it's asking for more information.
Yeah, but still
not that detailed. Yeah. But how do you see that change in like the practice of merger filings, and will that change the interaction with the authorities in the US? How do you see that?
So I think that in the US, quite frankly, what typically has happened, and first of all, the 4C documents, which I guess other jurisdictions never used to have, but are now adding, that, quite frankly, has been the most significant part of our filings, because those are the documents, as a practitioner, when I used to see the 4C documents, when I wasn't involved in a transaction until too late, that's when I used to, nightmare, exactly. This will allow us to eliminate our most effective competitor and raise prices. Well, this is a problem. So the 4C documents are the other thing is the government in the United States, and I don't know whether you have this in Brazil, but when you file Hart-Scott, and first of all, when we file, we don't have to do like you do here and elsewhere, where you have to submit a draft and they have to come back with wanting additional information. We file, it starts the clock. But if there's a transaction that has an issue of any sort, even if it's not a significant issue, but they're horizontal competitors, you will typically get in the United States what's called a voluntary access letter within like the first week or two, which asks you on a voluntary basis to provide information on, so for example, provide your strategic plans for the last 5 years. Like your business plans, provide a list of your competitors, list of your top 20 customers with their names and phone contact information. So that is, quite frankly, I think is something that I know it's something that the government continues to use. And actually, I think it's much more, it's a much more targeted approach, and allows them to start an investigation, a real investigation, quicker, to know whether they need to go into what would you call phase two, what we call a request for additional information, second request. So I see that as more important than any changes, any tweaking to the Hart-Scott form, because that's really where they get their information, and it allows them to really focus in immediately as to what customers are thinking, who the competitors are, and looking at strategic production, so you can provide what you want. But you always have this issue is if you know your transaction is going to a second request and all of these things have to be provided to the government, you're in a better position in terms of your relationship with the government to provide everything they've asked for, as opposed to withholding the bad documents, because otherwise they're going to get the bad document. It's going to be made worse because they know you had it and didn't give it to them, even though you weren't required to give it to them. So, and I've had that issue come up constantly.
A follow-up question. We know that the court lambasted Google for using temporary messages or incentivizing employees not to put in writing their discussions, exactly in order to avoid the creation of bad documents overall. But do you see, and we also at the same hand, we know that, for instance, the SEC has also fined banks a lot for not using the proper channels for communicating with clients and making the proper records. That issue of document creation and record creation in terms of merger filings, is that a trend or an excuse among companies not to produce the documents, not to create them at all in the first place, to say that something has not been created? We know that as lawyers, that is something that goes without saying, but in terms of this being reflected somehow in those requests or voluntary letters.
So well, by the way, one of the worst things I always see and have had seen many times is when somebody says, somebody writes to someone and says, let's take this discussion offline. Always not a good thing to have. But
sometimes it's better than the option, right?
Yeah. So, one of the things I do tell, if I'm involved early, when I was practicing, I'm not practicing anymore, luckily, but when I was practicing, I would, our guidance was always, as soon as we get involved, is to let the clients know what a 4C document is, and so that they know now, writing documents going forward, that these documents are going to have to be provided to the government. That includes not just, these formal presentations, but emails. And emails are the worst, obviously, because people are just writing very casually and they're not worried about they're not thinking anybody's going to see it. We have not got, at least in my experience, which ended in 2015 in terms of practicing, we haven't gotten to having to provide like text messages and things like that, but maybe sometimes, I know they're being asked for, but I don't know whether they're being produced or not, but emails are, a killer. But we definitely would advise clients not to, let clients at least know the bad types of documents and let them, figure it out for themselves that they shouldn't be writing them. But, we don't encourage clients to write documents that say, let's not put this in writing, that sort of thing. But hopefully they get that message. But I do think that people, to the extent they're realizing it, they would realize not to put things in writing. If you'd be amazed, I mean, you're probably not amazed because you see it yourself, but people don't think that things that they're writing are going to be seen by somebody other than the person they're sending it to. And that's, I practice, even though I did primarily antitrust and competition work, I did other trial type work. And, it's not unique to businesses to discussing competition. People just don't think that what they're writing, particularly in an email, is going to be seen by anybody other than the recipient, which is not the case.
Questions from our audience outside? I don't think they can speak, right? They
have to.
Yeah, they can send in Q&A. They can use Q&A or chat. Well, I had one additional one that is Biden administration is really pushing the boundaries and trying new theories of harm or pushing things that were like far forgotten, like potential competition issues on the meta within case and
Mhm.
very unsuccessfully, right? I mean, in many cases, but they're still trying that. And sometimes actually getting narrow paths forward, right? Like in the meta within, I think they lost the case, but the judge said, well, in theory, potential competition could be through a farm here. So they're kind of like pushing the boundaries of antitrust in courts. Do you see a retreat from that? Like, so we're going to be more in the traditional theories of harm, consumer welfare discussion, and things like that?
I think a Republican, putting aside Trump himself in terms of his own views, I think a Republican administration, it clearly is not one who pushes the boundaries. Is definitely a much more traditional approach. And if anything, approach that, in terms of efficiency defense and not the efficiency, not the America First efficiency defense, but an efficiency defense in terms of, it's definitely a favored thing by Republican administrations because it says that the companies are going to be more efficient and therefore, and you should reward efficiency. One of the things we have and that's from a Supreme Court case, I don't know whether you have something comparable here, is that the antitrust laws are to protect competition, but not competitors, okay? So this is a principle that is very much, I think a Biden administration obviously would give credence, would have to subscribe to the fact that we protect competition and not competitors, but they'd be much more receptive to competitors are being harmed and therefore competition is being harmed, as opposed to a Republican administration, which is more receptive to the argument that maybe competitors are being harmed, but that's because they're weak and they're inefficient. But competition is enhanced by having strong, effective competitors. And that's why there's the Chicago School, more Republican-oriented economists oppose the structural presumption because they say that is a false predictor, and that in fact the reason why you may have better profit margins and the like is just because the larger companies are more efficient companies, not because they're anti-competitive, not because there's a lessening of competition.
Sure. Last question on bureaucracy. Has the FTC been already affected by efficiency cuts in personnel budget?
That's one. I have not heard of their cuts yet, but as far as I can tell, he's not sparing anybody. So, although I've not heard of that being cut. I'm sure they will be, though.
Do you think that can affect enforcement?
Oh, sure. I mean, if you have fewer people, they're going to have to be much more selective in terms of which cases they're going to be going after. And the thing with the FTC and DOJ is, in terms of the antitrust division and Federal Trade Commission, they have typically attracted people who are committed to antitrust enforcement. Okay, I just know from students. The students who are interested in going to the FTC or the antitrust division are very pro-consumer. They're not going there because they want to, build up American competitiveness. So there's going to be a real tension there in terms of, to the extent that they try to inculcate their ideology, a more America First ideology. And one of the things that's going on, obviously, is a purging of people who don't share the not at the antitrust level, but in other types of positions. It hasn't gotten to antitrust yet, and I don't know that it will. There's a lot of ground to cover in terms of weeding out people who don't share the same views, and I don't know that antitrust is getting to the top of the list as opposed to DEI or climate, whatever. Those are much more important issues, but I do think that ultimately there's going to be there will be a tension there, just because I know the type of people who I've dealt with at the FTC and the DOJ, the career people. I'm not talking about the senior people, the career people and the tech people who they recruit. Those are people who are very pro enforcement. So.
Any further questions? No, I think we're like 11:35, so we're just like 5 minutes beyond. And so I'd like to thank you, Joe, for the great talk and the conversation that we had. Very enlightening in this period of turmoil. Let's put it this way. And I'd like to thank VMA for hosting us and thank IBRAC for putting this together. And with that, I give the floor to Renata to close our work here.
Thank you. Let me thank you again, Professor. It was a very live discussion. As you can see, there's a lot of questions here, and you are more than welcome to come anytime you want and speak here with our group. And thank you, everybody, for coming.
Thanks for coming.